So without further ado, welcome. And I'd like to introduce our very esteemed panel and thank two of them from coming in from New York, and our third, Jason Leopold, who's live from LA. And sorry, he was not feeling ill and couldn't make it to be here in person, but I know he's not feeling well now either. So we really, really appreciate, Jason, you being on this presentation for us.
Glad to do it.
With us. So from your left to right, we have Tim Tai. Tim's a graduate of Yale Law School. He graduated last year, was also in the Mafia Clinic, and he's now a newsroom lawyer at the New York Times. Prior to that, he was a photographer at the Columbia Daily Tribune in Missouri, and also the Philadelphia Inquirer. So welcome back to Tim. Thank you for being here. And then we have Al-Amyn Sumar, who's senior counsel at the New York Times and also handles all news gathering issues, including intellectual property, subpoenas, pre-pub review, clearly FOIA, and libel and defamation as well. And prior to the Times, he was a fellow at the New York Times and also at Ballard Spahr and Levine, Sullivan, Koch, and Schultz. So, and you've also served on the panel, correct?
I have, yeah, it's been a few years.
Great, great. Well, welcome back. Pleased to have you. And we have Jason live from LA. Jason is been referred to as a FOIA terrorist by at least one agency. I like to refer to him as the FOIA czar. There's not one person who has used FOIA so adeptly and successfully than Jason Leopold. And he also has definitely litigated more FOIA cases than any single person or entity in the world. And so many important stories would not have gotten written without his tenacity and his use of FOIA just expertly. And we are so delighted and thrilled to have you here with us, Jason. Jason was inducted into the National Freedom of Information Hall of Fame. He's a senior investigative reporter at Bloomberg and is twice award-winning on many awards for international health investigative reporting, and also has been a Pulitzer Prize finalist 2 times. So I'll let you all begin, and welcome. Thank you for coming.
Thanks, Jennifer.
Just like out of curiosity, people in the room, how many are law students or lawyers? Okay. And are there journalists in the room too? Okay, a couple. Yeah, I mean, I think the goal here, I'm going to make Tim do a lot of the talking for the time slides, and Jason, he'll turn it over to you. But obviously, like, this is a conversation among us, and feel free to jump in whenever. I think the goal here is just to give you a basic grounding in FOIA, and some of what we're going to talk about you may already know, but also to kind of talk about what we've learned in our practical experience. Jason probably has more experience with FOIA than anybody, at least when it comes to the news side. So yeah, this is meant to be kind of helpful to you, so feel free to jump in with questions anytime. And with that, I will turn it over to Tim to give you reasons to subscribe to the New York Times.
Just a quick little promo video, but
in government is not something that came out on the news. Secrecy around
I got to get one of those.
This is part of Tim's job is to fill a subscription quota for the year, and he's a little behind, so.
Get to the next slide now. Oh no. It's not gonna let, okay, hang on. We'll just start from this one. Okay. So the point was not to sell the New York Times to you guys, but just to show that that commercial came out, I think, during the first Trump administration, and I think on all of our minds right now is how FOIA and public transparency will be handled in the current administration. And I think, we'll talk about reasons for concern about how, FOIA officers may be getting laid off, and it may be just becoming increasingly harder to get public documents from federal agencies. But that's not to say that we shouldn't be trying. So this is just a brief agenda. We'll start with a brief overview of FOIA. We'll talk about, some of the obstacles for FOIA compliance. We'll go through sort of how to create a FOIA request, considerations and tips, sort of the process for an agency once it gets a FOIA request, and sort of the various remedies that you might have as a requester if your request is denied or if an agency doesn't respond. We'll do a brief overview of the various FOIA exemptions, and we'll end just by sort of talking about considerations when you're seeking records from state or local agencies. But first, what is FOIA? FOIA stands for the Freedom of Information Act. It's a federal law. It was first enacted in 1967, and it has been repeatedly amended since then. And it allows basically anyone to request records or copies of records held by executive branch agencies. And that sounds great. There are a lot of caveats to that, as we will get into. Al-Amyn, do you want to do this one?
Sure. Yeah. I mean, as Tim mentioned, the kind of vision that led to the enactment of FOIA, and I think drives a lot of the work today, is this idea that people should know what the government is up to. And FOIA is a statute that, at least at the time it was enacted, really didn't exist in any form around, in any other country around the world. I'm not a proponent of American exceptionalism. I'm actually from Canada. But I think FOIA is sort of one of the things that makes America great, and has led to like a lot of similar legislation in other parts of the world. But as Tim said, the theory and practice don't exactly match up. And Jason can tell you this too. It's extremely slow at some agencies more than others. There's lots of abuse in terms of like how it gets administered by FOIA officers and others at the administrative level. And a lot of FOIA requests and litigation are actually just private companies who are trying to get information from the government that is helpful to their bottom line. It's a lot of like one corporation trying to find information about other corporations, or that kind of litigation is actually a greater and greater share of overall FOIA litigation. And so, yeah, the extreme delay means that a lawsuit is often only the only way to obtain documents. Next slide. And as I said, when you're dealing with FOIA officers, a lot of them, whether because it's sort of easier for them or because they're operating in bad faith, they tend to take a very narrow view of what their obligations are and a very broad view of the exemptions. And I think under the Trump administration, it's still very early days, but it's fair to say that the delays, the problems that we already have are only going to get worse. There was a story CNN did a little while ago about how OPM has essentially fired its FOIA officers. I think probably with the cuts that are being made across the federal government, you're going to see more of that. I don't know how that's going to translate into litigation, like whether those sorts of delays are going to become more common, whether judges are going to tolerate that. But I think the challenges are only going to grow.
So I think it's just worth stepping back for a second and thinking about the role that FOIA plays. As Al-Amyn said, it's this idea that, the public should have access to information about what their government is doing so that they can know if the government is working properly, if there are things that are not working, basically to hold the government accountable. And if you can just imagine, like, if there were no FOIA, if there were no public records law, there basically is no right to this information in any other sense. There's no constitutional right to get information about what your government is up to. And so FOIA, even though it's just a statute that Congress has enacted and could change at any time, really plays an important role in allowing the public to understand what government agencies are doing, why they're making decisions, how decisions are playing out, sort of behind the scenes, how they investigate wrongdoing and whether they are investigating wrongdoing. There are all kinds of things that we otherwise would not have access to. And so it can be very powerful at its best. So just to start with, who can you FOIA? Well, it has to be an agency of the federal government. So this doesn't include legislative bodies. It doesn't include Congress. It doesn't include judicial bodies. It includes executive departments, the military, government corporations, and any other sort of executive entity, but not certain entities that are really like close to the president. So you can't FOIA presidential records. That's controlled by a different law. There's an ongoing question about whether DOJ is subject to FOIA. Some of you may have read that DOJ has been sort of swept in under like the executive office of the president to sort of insulate it from FOIA scrutiny. And there are a number of lawsuits that are challenging whether that's proper right now. But the theory, I think that the administration is working under is that if you say DOJ is basically like an advisory body to the president, then it shouldn't fall within the definition of an agency under FOIA. Yes, I saw you had a question. I'm sorry, the Department of Government Efficiency, the thing that Elon is allegedly not leading. And then just a quick note, just at the state or local level, these laws vary across the board, but usually you can get records from any sort of state or local agency under most states' laws. And some of the laws are actually broader than that, which we'll touch on at the end. Jason, do you want to take this one in the next few? Oh, we can't hear you, Jason.
Apologies, I had the mute on. Every time I put it on, I'm like, I hope I remember to turn it off. So what can you FOIA? The agency has to have created or obtained records, and it's in control of that material. It's put into a record-keeping system. And, many FOIA requests consist of, give me all of your emails. I'm notorious for that, by the way. And memos and documents and reports. But there's also other things you can FOIA. You can FOIA videos. You can ask the FBI for videos from a certain case. It may take a really long time, but you can, that would be considered a proper request. The Department of Defense has an amazing library of historical movies and videos. Some may call them propaganda videos, but that's something you could FOIA. Sound recordings, computer tapes, and importantly, when you ask for this material, particularly if you're looking for data is something that all agencies obviously maintain. If you're looking for immigration data, for example, you always want to be sure to request it in its original format. But physical objects, for example, presidential gifts, and I can tell you that I've seen requests to the State Department asking for copies of statues that President Trump had received. And that's obviously not something you can ask for. We're not at the point yet where the agencies are using a 3D printing machine and reproducing anything like that. But essentially, you want to make sure that the records that they're in possession of the agency, they're in a record keeping system. Be aware that sometimes you may get a response that says the record you're seeking is a congressional record, even though the agency has it, and therefore would not be subject to FOIA. So do you guys want me to take this one?
Sure. So when you're submitting a FOIA request, you have to do it in writing. Annoyingly, every agency sort of has their own system of how they want to receive requests. Many of them will accept requests by email, and there will be an email address listed on the agency's website that it needs to go to. You can't just sort of send it to any single person there. Some agencies have like websites that are like online portals where you like create an account and you can upload requests, and you can sort of monitor the progress of your requests that way. Some agencies, only a few, but like the CIA, say you have to mail in your request, which obviously can be very annoying. And it also means that they will mail you back their response, which can be very annoying. So just be aware that each agency may have their own procedures and rules about this. When you make a request, you have to what is called reasonably describe the records you're seeking. And that standard means that it has to basically allow an agency employee to sort of figure out what it is that you're asking for with a reasonable amount of effort. And so a lot of times, we work with reporters who just, they're not sure what might be out there, and they just want sort of all records related to this thing. And a lot of times the agency will say, we can't fulfill this request because we don't know what it means for something to be related to this topic. So it really is helpful, as we'll get into in a minute, to include things like emails with specific keywords, emails sent from or received by particular individuals, within a specified time frame, or from certain like web domains. The more specific you can be, sort of the higher the chances that the agency will be able to produce what it is you're looking for. Jason?
Yeah, so when you're approaching the FOIA, going into it, when you're filing a request, one thing you have to be aware of is certainly the dysfunction at the agencies, but the backlogs that exist within federal agencies and even in some state agencies could result in just you're not going to get records in a timely fashion. So this is where I would just like to, for a moment, say, as a journalist, I wouldn't necessarily say guilty, but I would often file broad and sweeping requests. And the times that I did file broad and sweeping requests, I knew that I was going to sue, the agency. And even if it took them 5 years to give me the records, that was okay, because I needed all those records and wanted all those records, and it was important for the reporting I was doing. So now, because many of the requests that are filed, and I've seen them from a wide range of individuals who often ask, why can't I get these records? And why is it taking so long? Well, it's because you asked for every single email from the Department of Homeland Security. And you've asked for it over a span of 5 years. So this is where, as a journalist, I approach it differently. And I explain that anyone, can and should approach it this way in order to get records quickly, is that because too many requests are considered broad and burdensome, right? And that is something that is in the regulations that state if it's broad and burdensome, it will take up too many resources within the agency. They can deny it or ask you to narrow your requests. But if prior to filing the request, it's important to find out, one, what are you looking for exactly? To conduct the kind of research that's needed at the front end before just firing off a request. And I often say this to my colleagues, is that you need to approach the FOIA as you would an investigative story. So if you know if what you're looking for exactly, that's where you do want to include keywords, search strings, identify the custodians of the records. You can do that by, sometimes you can look at the agency's organizational chart. But by, in every instance, you want to try to avoid that. I want every email from 2024 through 2025, because that is just going to take years for an agency to process.
And I just want to add that, for those of you who are law students or lawyers here who have had to do doc review during your internships, agencies are basically using like e-discovery software to search for, written records, emails, and so forth. So if you are asking for things that will turn up thousands and thousands of potentially responsive documents, it is natural that it would take many hours for someone to have to go through all those thousands and thousands of documents to see if they are actually relevant to your request, and then to see if things need to be redacted and whatnot. So that might give you a sense of how the process is working. And I also want to add that this is not really in the statute, but most agencies have these sort of internal procedures where they'll classify a request as either like simple or complicated. And it's just like someone looks at it when it comes in and says, this is a very narrow, straightforward thing that we can just sort of do here. Or, oh, we have to go call different offices of the agency and search multiple people's inboxes, and it, maybe these are paper records, whatever. And sometimes how your request gets categorized can really make a difference in the time it takes to respond. And so that's just something else to be cognizant of, is just how an agency is processing these things internally. And Jason, this is one of your requests, right? And
yeah, so this is just to kind of back up what I was saying previously on how to perfect your request and how to target exactly what you're looking for. So as you can see, this was a request to the Federal Housing Finance Authority, and it was during the failure of Silicon Valley Bank and Signature Bank, and I put in a lot of research in, prior to filing this request. So as I said, as a reporter, I approach each request for the most part as if I would approach an investigative news story. And that means I am searching for people, for conducting research, people who can advise me on exactly the type of record that may exist. That means finding the title of a report, the subject line of an email, the date of an email or report, who the individuals were that may have received it. So with this request, I couldn't get as much as I wanted to, but I had enough to know that, particularly in part 2, that there were quarterly supervisory reports, and that was something very, very specific that the agency had. And that came from, a person who worked at the agency, who provided me with that information. And then number one, the internal rating system, where, they rate these financial institutions, these banks. That was another, type of record that I knew existed. And then on the others, or at least number 3, I kind of just went and, give me these records, that just reference this. And the reason I threw number 3 in is because I already knew that filing this request, I was going to sue. And I wanted to have all those communications and find out what was going on behind the scenes. But as you can see, you know, in the last part here, I'm also, you know, I instructed the agency where to search, right? I told them that I wanted GS 15 and above, and GS is a general services, you know, it's a pay scale within the federal government. It means you're a little higher up on the food chain. But I went through the agency's organizational chart and I, you know, found which components within that agency would likely have those records, you know, and that's why I identified all of those agencies. So that's the kind of research you want to conduct before filing the request, because it will give you a better understanding, one, of what this agency actually does, how it functions, the kinds of records that they have. So this way, you know, you won't be getting an email back that says, we don't understand your request. Can you refile? Can you explain? And you will lose a couple of months from that, you know, just due to the fact that you're having to explain all of that.
And what did you get out of the request and litigation?
Well, I got a ton of records. In fact, the litigation's still ongoing. But what was really, I have to say, what was really great is the agency sent me a bunch of records they forgot to redact, and then they wanted them back, and we said no. So yeah, that's kind of one of them. But and believe it or not, this actually does have to do with Silicon Valley Bank, but this is another agency. This was the FDIC that forgot to redact. So I have two agencies that, you know, that forgot to redact it, but it kind of just showed what the market value was on, you know, the records that I got on, you know, the bank prior to trading, whether anyone had insight into what was, you know, what was taking place. And largely it just showed, you know, who knew what and when. And that was really helpful in order to put, you know, that narrative together on the story. So it did result in a number of records. And like I said, it's still ongoing.
I just want to point out a couple of things that Jason is doing with the request. First, I think, as Jason said, like, it's important to sort of point to the specific records you want. So imagine if he had said something like records related to safety of banks, right? Like the agency would probably come back and say, well, we don't really know what it means for a record to be related to the safety of a bank. But Jason found that there are these specific types of records, this internal rating system, these quarterly supervisory reports. And so he was able to, you know, point the agency directly to those types of records. I also think the time frame he's using is something that is a good trick that we use a lot, which is, you know, a lot of times an agency might take months to fulfill a request. And so having a time frame that says, you know, a date through the date that this request is processed or through the date that the search is completed will ensure that you're sort of covering as recent a time period as possible. If you are seeking records where there may be like new emails or something that fit the bill being created every day, and you want to capture those and not just, you know, emails that sort of ended 6 months ago or a year ago or something. This is not to criticize Jason. I think, you know, if you are seeking emails or things, sometimes it's helpful just to be clear that you want them to run, search for specific keywords, or giving them specific email domains if you know them. You know, sometimes an agency will say, oh, well, we don't know what other state officials you were referring to. But I think in this case, this request worked, and, you know, agencies, if they don't get specifics, are basically going to make a reasonable guess as to where to search or whose emails to search. So if Jason didn't know which offices or custodians he wanted, the agency would have just sort of guessed who it thought might be the right email inboxes to search. And sometimes that's helpful if you don't know, but sometimes that's not helpful because the agency may not really be thinking very hard about what to search, and you don't really know what they're searching. You just sort of have to take their word that they did a search. So that's why that sort of pre-research is really important. Jason, do you mind taking this one too?
Sure. So, you know, again, as a journalist, I'm in the kind of fortunate position where I can ask an agency to provide me with a fee waiver, and essentially saying that the records I'm seeking are in the public interest, and I plan to release them and inform the public about about the records I'm will hopefully receive, and that I will use it as the basis, for my reporting. It's going to contribute to the public's understanding of the particular subject matter and actual government activity, what the government's sort of role in it was. But what's really important is to you have to demonstrate. And I'm saying this as a journalist. It didn't sound like there were many journalists there, so maybe there are some watching. But oftentimes journalists will say, "I'm a journalist. Give me the fee waiver." But you have to kind of demonstrate, that how you will use the records. Oftentimes journalists don't want to do that because they fear that the agency is going to tell someone, like, oh, if we give them these records, they're going to write a story. Well, that's already, the cat's out of the bag just by filing the request and saying you're a journalist. But you have to explain, why you are entitled to a fee waiver, how you will use the records, how it will contribute to the public's understanding of the operations or activities of government. And for anyone else, there may be other ways in which you can you can get a fee waiver. I mean, obviously, you're not asking for the records for commercial purposes, meaning that you're using that information maybe to sell it. So you have to include all of that in the request. And with expedited processing, this is a tricky one because every agency has a different regulation. For the most part, they all you can get expedited processing, meaning the agency would treat your request in an urgent, expedited fashion and try to get you records faster. But again, you have to demonstrate, why the agency should do that. How does it, relate to actual or alleged, federal government activity, and that, you're using it to inform the public. So one thing to keep in mind that since these backlogs have grown at agencies is that it takes longer to get records on an expedited track than in some instances than it would if you didn't ask for expedited processing. If I'm not mistaken, I think that is the case with the Department of Justice. Why is that? Because lots of people are filing requests for expedited processing, and the Justice Department happens to be the easiest agency to get expedited processing from. And it's helpful, if they're not taking or if they're not giving you the records in that sort of expedited fashion. It helps if you're litigating, to try and get it that way. But again, these are these are details that you want to keep in mind before asking for that. And I'm going to promote FOIA.gov, which has a pretty good resource on there for providing requesters with the kind of the average time it takes for a complex request or a request that is considered simple in terms of how many days. So you may want, it may be something you want to check, but it's very important that you just don't sort of, write in your fee waiver that, I'm this person, therefore I'm entitled to it. Yeah, again, you have to demonstrate that, and the same with expedited processing. So as I mentioned before, it's really important going forward, especially now, under this administration, because it's chaotic, and that chaos has impacted the FOIA. So it's important to approach each, public records request at the state and federal level as if you were approaching an investigative story. But even if you're not a journalist and you're a law student or a lawyer, you kind of want to do the same kind of work. And that means trying to obtain as much information about the subject matter of your request before you file it. If you put in 2 weeks of research, that 2 weeks could save you 6 months going back and forth, and where the agency's trying to figure out what you want, or if you land in the complex track, and you just fall into a black hole. So investing the time in researching, the details about that agency, how the agency functions, the types of records that agency stores in a record-keeping system. You can sometimes find that on Google. As I mentioned, you want to get the email subject line, the date of the report, the names of custodians that are referred to at an agency, the people who work there, maybe whose emails you want searched. And what I do is I try to find people who work at the agencies, sometimes in the FOIA offices, who can provide me with that info. I call that intel. It's very valuable. And lastly, it's going to go a long way if you become an expert at the way an agency functions. If you know the ins and outs of the Department of Homeland Security, for example, which has multiple different components within DHS, that includes the Office of Intelligence and Analysis, Civil Rights and Civil Liberties, ICE, CBP, and the list goes on, and kind of just study just their, on their websites, going to their FOIA reading rooms. That will go a long way, when it comes time for you to file that request. And it will help if the agency actually says to you, we don't have records, or we searched here, and maybe that the record does exist and they just didn't, conduct that, that reasonable search that they are supposed to conduct. And yeah, so here's the, an SEC organizational chart. Again, a lot of requesters will file a request to the SEC, the entire SEC, without really kind of understanding that within the SEC, there are multiple divisions and offices and components that deal with all sorts of matters. And so if you are asking about an investigation, into, I'll throw it out there, Roblox, which the SEC has looked at, you may want to go to, the enforcement division of the SEC. The office of the chair, I highly doubt is going to have any records, but that's the kind of information you want to figure out before filing the request. So studying an agency's organizational chart, you could just type in the agency and org chart, into Google, will go a long way in terms of helping you further narrow that request to a very, very specific component. So again, you're saving yourself time. All of this is designed to, save months and months of back and forth, with an agency's FOIA officer.
Sorry, Jason, sorry to interrupt. We have
Yeah.
a question that I thought would be perfect for now. Could you please describe what a FOIA reading room is and how to find them? Is it
Sure.
just on-
So, and this goes for the state level as well, that every federal agency has, sometimes you scroll to the bottom of the page, it gives you the sort of about us and, who they are and, how to contact them. But there will also be a link that says FOIA, right? Because FOIA is a law. and they have to provide information on how to, how to send a FOIA to that agency. So if you click that link, it will bring you to their FOIA page. And there on that page, it will also show you another link to a reading room. And that reading room contains documents that have previously been released. Not every agency does this. I can tell you that, DHS, I used them as an example before. They have not updated it, but, the Office of Director of National Intelligence does, the NSA does. They will release the records. The Department of Justice does a lot. And they will post the records that have been requested on the reading room. Now, that's sometimes not everyone likes that, particularly if you're a journalist and you don't want anyone else to know what what you've requested because they move fast. But, leaving that aside, these records are in the public interest and, they're being shared for that purpose. Hopefully that answers the question.
And Jason, do you want to talk about how you might use that to your advantage as a journalist?
So, noting that, my fellow panelists work for the Times, but sometimes we journalists want to see like, gee, how did someone else get this record? So on that reading room, there often, it's not always updated, but it's there. There are FOIA logs, and those logs contain what everyone else asked for. So you can see what, certainly what journalists asked for, what any member of the public has asked for, and even, commercial outfits, what they're requesting. So the log is very informative in terms of seeing, who asked for what, and has anybody, duplicated your request. And I can tell you in this case, this was the image that you see on the left, on your left, is something that appeared in the Financial Times. It was again related to Silicon Valley Bank, and it was from the FDIC, and it was basically supposed to be, what they requested. They asked for a record that would provide insight into, the largest depositors in, their Silicon Valley Bank's top 10 customers. So my colleagues and I saw that, and we thought it was interesting, right? It was already, printed in the paper. So we kind of wanted to work on a story that may be related to it, see if we could, sleuth out that redacted before information. And that is, that relates to trade secrets and commercial financial information. It's a real tough one to overcome. So I filed the exact same request. And what I said to the agency was I would, I request the same records that, Financial Times requested about Silicon Valley Bank and their largest customers. The FDIC responded with the document you see on your right, completely unredacted. Later that evening, after I received that document, I also received a letter from the FDIC that instructed me to destroy the record, brought up all sorts of threats about prosecution, and ultimately, we sent this to, I sent it to, our newsroom lawyers who looked at it and you can't put the genie back in the bottle. They had no grounds for, for demanding that back. And we wrote the story, and it was a result of just asking for the same record. So call that luck. Sometimes accidents happen. It's happened quite a bit actually in my, with me, where, an agency will, give me a record and forget to redact. But I always read the logs because it's informative, because journalists only make up a sliver of all the requests that are filed within federal government. Sometimes it's, oftentimes it's, commercial requesters who, are the, make up the bulk of the requests that are filed. But, even other members of the public may, ask for a specific record that is, you sort of scratch your head, is like, I wonder what that's all about. So it's, it's just good to be mindful of, it's a good practice to be mindful of, what is being requested, particularly since the government, federal government has received more than 1 million requests. The use of FOIA has skyrocketed. Okay, so this is the moment in time where I kind of realized this is why I do what I do. This is why for me, this was a Matrix moment. This was where I felt like Neo at the very end of the first Matrix, and was able to.
Do people get that reference?
What's
I
that?
think really we're dating ourselves here, Jason.
I know. Come on, there was a recent Matrix movie. I mean, it was part
That's true.
4,
That's
but
true.
anyway, so it was just this moment where all of that practice, the years of practice of filing requests and reading documents, I felt this was the moment it was put to good use. So back in 2016, late 2016, I sued the FBI for a wide range of records that they had on Donald Trump prior to his running, prior to his announcement that he was running for president, right? So I wanted documents that preceded his run for office. So I sued the FBI, and they gave me many records, but they were heavily redacted. And there was a particular record that they gave me that is on the left here that referenced, I think referenced extortion. And it was redacted under a privacy exemption, right? So a privacy exemption, and then, another privacy exemption that relates to law enforcement, information obtained for law enforcement purposes. But it was really interesting. As I was looking at this document, I could not stop staring at it. And there was, that zip code was just on the left here. It said New York, New York. And then there was a zip code. And I just stared at that document. And, what was helpful is that they put the last 4 digits in as well. So I just one day decided to put it into Google. This is probably 5 days after I got it, and I was obsessed with it. Put it into Google, and what came up was, like, one of the first entries on Google was a law firm in Lower Manhattan. I decided to, go to this law firm. I looked at the attorneys who work there. One of the attorneys represented the investors in Trump Entertainment. And I thought that was very interesting. So I tried to reach that attorney. Attorney would not speak to me, would not take my call. But there was also a reference in the completely redacted document, one of the pages there, that a local police station in New Jersey was also notified about some sort of threat. Had no idea what the threat is or was. So I found out where this lawyer lived in New Jersey. And again, just after using a zip code, and on a whim, total whim, I decided to file a public records request with in New Jersey with the the police department there, where where this person lived. And about 2 weeks later, and I asked them, I said, if you have any, any police reports on a threat filed by, the name of the attorney, please turn them over. This is what I'm asking for. 2 weeks later, they gave me the a document, and it turned out it was the police report, and it contained, if you can see in the, you know, the highlighted part here, hopefully you can read it so I don't have to repeat it, what's on there, because it's a pretty serious threat. The person received a threat from somebody named Carmine, essentially saying, if you F with Trump, we're coming for your wife and kids. And you know, and this threat was made, by the way, from a payphone outside of the Ed Sullivan Theater in New York City on the very night that Donald Trump was appearing on Late Night with David Letterman, a talk show that happened to have been filmed there. And suddenly I started putting all the pieces together, and I had this, you know, again, just from a zip code, I was able to unravel this, you know, what turned out to, in, you know, my humble opinion, felt like a really, really amazing story about an incident that took place, before, years back, before Donald Trump ran for president. And what was remarkable is that after I published the story, you know, was able to say I personally unredacted, you know, the FBI's report. The FBI about a month later sent me the documents again and they unredacted everything for me. I didn't even ask for it. They just did it, I guess, because I'd already done it. But point being, that's my long kind of winded story behind this document. But again, it's really important when you look at that document on the left, you know, the knee-jerk reaction may be, there's nothing here, and you just toss it aside. You know, for me, I just stared at those numbers and knew that it related to a privacy exemption, and something was wrong. Like why did they keep the zip code in if it's, you know, if there's a privacy exemption there? So I felt like there may have been a mistake. So really, really closely reading documents, even if it contains all those, you know, redactions or material that's withheld, you may actually learn something just from the exemption itself. So
yeah, I can take over here, and I might just zip through a bunch of these slides because I do want to leave time for questions. Then maybe I can actually pause here to see if anybody does have questions. Okay. So, you know, I call FOIA diplomacy like a very important part of the process in terms of, you know, getting information about the status of your request and trying to move things along. I had a line in here about shaming Gen Z, but Tim made me take it out. Basically, I think there's like an aversion in younger generations to like picking up the phone and calling people. Even I am, you know, disinclined to do it often, but especially with state FOIA officers, when you can get somebody on the phone and actually talk to them and show them that there's a real human being on the other side of this. And also for you to understand that there's a real human being who, you know, maybe is trying to process your request, it could actually yield a lot of value. Sometimes you can actually get things to process faster, but often it's just like an easy way to get information when emails might not be working. And, you know, the one thing I would say is just like, think very creatively if you're in a situation where you're trying to get your request processed as fast as possible, right? Are there things that you can do to narrow the scope further, even if you've done all the things that Jason talked about in terms of doing research? Can you ask for rolling production so that maybe you don't get 500 pages next month, but you get 50 of them or 100, right? Get a lawyer involved, sometimes even copying. You're mostly lawyers, but for the journalists here, like even just copying a journalist can be actually effective, you know, when you're corresponding with a public records officer. And just try to think of out-of-box solutions that will help the FOIA officer get you the records faster. You know, some of them are just going to stonewall you and they're operating in bad faith, like I said, but some of them, you know, can actually be partners for you and helpful. And sometimes FOIA public liaisons can be good. It really depends on the agency.
Do you want to explain what that is real quick?
Yeah, there are, you know, basically in addition to FOIA officers at designated agencies, there'll be like somebody called a public liaison who doesn't really have any authority, but can sort of help you kind of like mediate or think through, basically advise you on FOIA requests. So, you know, it's not something that I've often done most of the time I've tried to go to the FOIA officer who's the source and develop a relationship, reach out to them. But there is this other person as well that if you're really like running, yeah, Jason. Or is it?
Sorry, I actually coughed. I didn't mute at the time.
Okay. No worries. So just the sort of basics here on like timing and appealing and all of that. So I mean, the amazing thing about FOIA is you don't actually have to wait until you're denied to go to court. They have an obligation to make a determination under the statute within 20 business days. In cases of unusual circumstances, they can get an extra 10 business days. But if they don't do that, like they don't have to give you the records, but at least have to tell you, that they're going to grant or deny the request. If they don't do that within the allotted time frame, you can go straight to court. You can sue, and our boss calls it concierge service when you go to court. Basically, you kind of jump to the front of the line because now you're dealing with a U.S. attorney who's representing, or an assistant U.S. attorney who's representing the agency, and you get prioritized. You're not at the back of the line. It depends on the judge and depends on the agency and the AUSA, but you get things much, much faster than you would if you were just, administratively appealing or harassing a FOIA officer. But if you're in the administrative phase and you are denied, you have 90 days to file an administrative appeal. And again, if the agency denies that or doesn't decide your appeal within 20 business days, you can go straight to court. And as I say here, the agencies can often give you a GLOMAR response, which is neither granting nor denying your request. They just say, we can neither confirm nor deny. And there's lots of law about when they can't do that.
I think just the important thing to remember here is that if you do get a denial, you have to file an administrative appeal first. You can't just sue. And so that is beneficial in some ways because anyone can file an administrative appeal. You don't have to be a lawyer to do it. Usually you have to include some case law or something in there, but even as a law student or a journalist, you could file one. Whereas if you have to sue, you have to get a lawyer, you have to find someone to represent you. That could be expensive or time consuming. But if you do get a denial, the law requires you to exhaust your administrative remedies first.
So benefits of filing a lawsuit, like I said, you jump the queue. If you prevail in the lawsuit or the agency changes its position in response, you can get your attorney's fees, which are huge. And you can get a judge to, if the agency is saying the information's exempt, you can ask the judge, and they won't always grant this request, but to review the documents in camera. That is to say the agency submits them and the judge looks at them themselves and decides whether the exemption is being appropriately asserted. You have the benefit of that too. And in terms of where you can file, it's wherever the requester is, wherever the agency is, or in DC District Court. And you have 6 years from when the request is denied to actually start the litigation. And we could talk about FOIA exemptions too. And I'll just zip through these. But Jason, if you have anything to kind of jump in with at any point, feel free. Just cough.
Sure. Yeah.
So yeah, the basic outline or structure of FOIA, as Tim mentioned, is that there is presumption of disclosure. Documents have to be withheld. The documents have to be released in response to a request subject to these exemptions in the statute. The government is the one that has the burden of proof to show that an exemption applies, and it has an obligation under the law to segregate the information that's exempt from that which is not exempt. So basically redact, right? Some of the exemptions are discretionary in that the agency can say, I'm waiving this exemption and releasing the information to you anyway. Some of them are not. The agencies actually have, when it comes to classified material, they don't have discretion. And this is very important. This is a provision of a 2016 law called the FOIA Improvement Act that has now been heavily litigated, including by Jason and the Mafia Clinic. Thanks very much. But there's now this additional requirement that in addition to showing that the information falls within an exemption, you have to show that some harm would foreseeably flow from the disclosure. And it's actually meaningful, and it's something that probably is not going to help you until you're in litigation, because the agencies always say, yes, and I think harm would foreseeably flow from disclosure. So you need to be in front of a judge to actually get movement on that, but it's an important addition to the law. So there's 9 exemptions in FOIA. Exemption 1 is for properly classified material. And it's very hard to get around when the agency asserts this, because the courts give huge deference when it comes to national security information to the agencies as to whether something is properly classified, right? They will put in a declaration from some person at the agency who's a classifying authority, and they say, we classified this information because it would do harm to national security. Courts say we're not going to second guess that. And so you're left with a very few options in terms of being able to overcome an exemption, an assertion of exemption 1. One of the ways is to say the government has actually officially acknowledged that same information. And it's actually, on the face of it, not a super useful doctrine, because the courts have interpreted it to mean that it has to be an official disclosure, so it can't be like anonymous sourcing. And the only information that gets waived or that's subject to disclosure through this doctrine is the exact information that's already been out in the public domain. It's more useful when it comes to overcoming GLOMARs. So when the government says, we can't acknowledge even whether records exist, because by granting or denying a request, we would disclose whether we have records about this. And sometimes you can point to some disclosure and say, actually, you've already acknowledged officially that these records exist. And so you can't GLOMAR me. You at least have to grant and, produce documents to me with redactions. But even that doctrine has become very narrow over the years, I think. We litigated a case up to the Second Circuit a few years ago where Trump went to Twitter, this is in the first administration, and basically talked about, he was criticizing reporting in the Washington Post about Syria rebel program at the CIA. And there's really no way to read that tweet other than to mean that documents existed. There was such a program, and the Washington Post had just actually gotten the facts wrong. But the Second Circuit, over a dissent, said this was not enough, and that the CIA's GLOMAR response in response to our request was proper. There's something called mandatory declassification review, where you can ask the agency to voluntarily kind of look at the records and decide that maybe the time or the need for classification has passed. That's always an option. I don't know of a case where that's actually worked, but
I will, can I chime in? And this was the Trump Syrian rebels case. That was something that we kind of the Times and we were both trying to get at the same records, and we were in different districts, right? You were in SDN at first, if I'm not mistaken.
exactly.
And it seemed like one of us was close to getting to that point. We got the GLOMAR. Ultimately, we got the GLOMAR lifted, but the government, at least in DC, the government appealed. So unfortunately, we lost in the DC circuit. But on the mandatory declassification review, so that is really that's just something I want to note, because I just got a document in response to an MDR after waiting 7 years, and it's really an extraordinary document. So mandatory declassification review is where a specific record exists, and you're asking the agency to declassify it under Executive Order 13526. But I received a document from the Office of Director of National Intelligence. It's a 2-page document, extraordinary. I saw a reference to it buried in an appropriations request in 2015 or 16, and it essentially asked the Office of Director of National Intelligence to provide a list of individuals who were killed on orders of Vladimir Putin as a form of statecraft. And so I filed an MDR for this back in 2017. And about a month ago, I got it. And there's never been any document like it that has ever been released. And I don't often file MDRs, but it's, if you know, it's the success rate on an MDR is greater than just asking for the record, you know, under FOIA. But the thing is that you can't do both at the same time. You can't FOIA it and then request it under MDR.
Right. That's a good point. Exemption 2, I don't think I've ever dealt with, but these are records related to the internal personnel rules and practices of an agency. Jason, have you ever had an Exemption 2 case?
I've never had an exemption 2. No. Yeah.
That's all we need to say about that.
Right, exactly.
Exemption 3 is where it's for information that's specifically made exempt by another statute. And so that includes things like Federal Rule of Criminal Procedure 6E, which deals with grand jury materials. We had a case that went up to, again, the Second Circuit, and we actually won this time. And it was about an Indian Health Service report about a doctor who was essentially a pedophile, and the agency knew this. And instead of firing him, they basically just kept transferring him to different jurisdictions. And the agency asserted Exemption 5 below, which they lost on foreseeable harm, and they didn't appeal that. But they also said that the document was covered by a statute because it was a document that related to medical care quality assurance, basically something having to do with like the quality of medical care. And we were like, yeah, it's not about, it was an investigation of this doctor. And we said it was not about the quality of medical care that he dispensed to his patients, but about his sexual misconduct. And the Second Circuit agreed with us. But basically, if there is a statute that says this information is exempt, you're out of luck because that Exemption 3 incorporates those laws. Exemption 4 is the one Jason was referring to earlier that can be very difficult to get around. It applies to things that are trade secrets and more broadly, confidential commercial information, which is a term of art in the statute that was kind of narrowly defined under the case law until this Supreme Court decision a few years ago. Up until that point, at least in certain cases, the courts required that there be a showing of competitive harm or commercial harm from disclosure. And the Supreme Court in this case essentially did away with that and said, confidential just means that it's information that the company keeps private in sort of the normal course, and maybe that it provided to the government under some assurance of confidentiality. And that has made it a lot more difficult to get information. But at least in the Second Circuit, you know, the appellate court has said the foreseeable harm provision of the 2016 law applies to Exemption 4. So actually, you still have to make some showing of harm, even for information that is otherwise exempt. Exemption 5 is one that comes up all the time. It's probably the one that comes up for us the most, I would think, Tim. And basically just says that the normal litigation privileges that apply in litigation with the government, so the attorney-client privilege, the attorney work product privilege, and the deliberative process privilege, which is very broad and basically says any document that relates to a decision made by the government, if it's not the final decision, or if it doesn't contain factual information, if it's part of the deliberative process, is exempt. It is very hard to get around. And you have to make some argument about, well, it was disclosed to a third party outside the agency. There's no foreseeable harm from disclosure. The information is purely factual, but it is very difficult to get around.
Or if the agency has essentially adopted whatever it was, you know, in a draft form or in discussion form as like an actual final policy or rule, then you can get around it. But yeah, it's something we encounter a lot. And it's something that is unfortunate because we want to know like why government decisions are being made, right? And this exemption really covers a lot of these emails or documents where officials are talking about why they're trying to do something.
Exemption 6 is a privacy exemption and basically calls for about balancing and says basically any, documents, and, it says personnel, medical, and similar files, but similar files has been interpreted very broadly. So basically, if there's information in which there is some privacy interest, more than de minimis, the court has to balance that privacy interest against the public interest in disclosure, and the relevant public interest is it going to tell us what the government is up to? And if the balance is in favor of the public interest, the information gets disclosed. It can be a hard exemption to get around, but often it's just a matter of redacting information, like information that identifies people, their age, contact information, things like that. So it can be easy to get around, but in some cases, we just had a case that got decided a couple weeks ago that had to do with information in a OIG report having to do with the FBI. There were these agents who would go abroad, and in some of the countries they were hiring prostitutes and engaging in, misconduct. And the court said, well, I can give you some of this information that you're asking for because it wouldn't identify these agents who are kind of low-level people. But some of the information you've asked for would probably lead to their identification, and the public interest isn't great enough to sort of warrant disclosure of that. 7 is a very broad exemption too, or at least it has a lot of components to it. Basically, it applies to law enforcement records whose disclosure would cause one of several kinds of enumerated harm. The one that comes up the most often is kind of interference with a law enforcement investigation or proceeding, where a law enforcement agency is investigating somebody or is in the middle of trial, and the information that you've asked for relates in some way to that. That can be very hard to get.
Can I note something on that?
Yeah, go for it.
I'm sorry to interject here. So, one thing an agency, and I believe there's, some case law in here, but I don't have the specific citation. So oftentimes, when I'm asking for records from the FBI, or, it could be even the Securities and Exchange Commission, or frankly, any agency, if it's particularly about a hot button news issue, the agency will respond by just blanket withholding everything under 7A. However, the agency needs to, it can push back on it to conduct a document by document search to determine segregability. If there's anything that could be, released that would not interfere, with an ongoing investigation. Agencies don't do that. And I do want to note that one thing that is new under this administration, and I got a copy of the Department of Homeland Security's FOIA guidelines, going forward. And those guidelines now instruct DHS personnel to, essentially never, ever respond with, withholding everything in full. DHS is now being instructed to, conduct a document by document search. And if anything, maybe you can provide just the email header or the subject line. So it's my opinion that like B7A has been abused for so long, because certainly not every single document would interfere with an ongoing investigation or a law enforcement proceeding.
Yeah, I think in practice, the FOIA officers, if it has any relationship to a law enforcement investigation or proceeding, will deny your request. But what they're actually supposed to show is interference, that some witnesses are going to be tipped off, that somebody disclosing knowledge of what the government has is in some way going to undermine what they're trying to do, which is a more difficult showing. And there are these other pieces of it too. I don't know if there's anything you want to add, Tim, on 7.
Not really, other than that, for those of you who may be requesting law enforcement related records, just know that there are a number of reasons they could try to deny a request. And so I think it's always in your benefit to try to submit an administrative appeal, at least, challenging, as Jason said, whether they have withheld too much or failed to give the explanation that they have to provide.
Right. And there is this threshold requirement that the documents be compiled for law enforcement purposes. And when the agency is a law enforcement agency, that tends to be an easier showing. But even in those cases, like, if it relates to how the agency polices its own employees and it's not necessarily legal violations, but violations of policy, those aren't law enforcement records. So think about whether there's a connection to law enforcement, force the agency to articulate a harm. Is the investigation closed? Is the proceeding over? Obviously, it's going to be impossible to show harm in a situation like that. But state laws can be really bad in this respect because there are places where if the document is investigative, it's just exempt. There's no showing of harm required. As long as there was some investigation at some point, it doesn't have to be released, which is it's absurd. I know you've had an Exemption 8 case, Jason, but I've never had either of these cases,
Yeah.
and I don't have a broad application.
So the good thing about, well, one, I did have an Exemption 8 case. I asked for a report that was prepared by an independent monitor after HSBC Bank was found to, years ago, to have laundered money for drug cartels and terrorists. And this was a 1,000-page report. The government, the Justice Department withheld it in full for a number of reasons, but Exemption 8, which essentially says, because of what Exemption 8 is, that they could do that. We appealed to the DC Circuit, and what was great that came out of that is that was it to the DC Circuit? I think it was.
Yeah, it was.
Geez, I'm sorry. And what was great that came out of that is that the foreseeable harm standard, which is from the 2016 amendments, it applies to Exemption 8, right? Which means that the agency can't just say Exemption 8, nothing. The requirement applies to Exemption 8, and the agency has to perform a segregability analysis for foreseeable harm. That may sound like nothing, but it's important because for me, it actually, even that little bit of info of what the harm could be, or would be, could be useful if I were to, put a news story together or try to. So, but leaving the journalism aside, it really does force the agency now, to, apply that standard where they have not been previously.
Yeah, the decision actually says they have to make showing a foreseeable harm for every part. I'm paraphrasing here, but every part of the document, which I was excited because we had a pending Second Circuit case dealing with foreseeable harm, and I submitted it as supplemental authority, and we still lost. But it was nice to see, and it was a good decision. So our thanks for that. And then I think this is the last slide. Jason, if you want to go, and then Tim, if you have anything to add.
Yeah, again, I would say that, with state public records laws, the only thing I have to say with this is that, apply the same sort of methodology in terms of requesting records as you would, as I discussed on a federal FOIA. One thing I left out, and this is really, really important. So we talked about how requesters will sometimes receive a response from an agency that says their request is broad or burdensome. This is kind of the best tip I can give everyone. And even to, my colleagues at the New York Times, if they're not using it already, which is the vast majority of records, when an agency says, we have 20,000 pages of emails, I can tell you that nobody's emailing that much. There's just no way there's that many, emails that would be useful. What you want to build into your request before filing it is, and this is really important on the state level as well, because you deal with fees, right? On the state level, you'll get an agency, response that says this is going to cost you $10,000 because they have to process all these records. Make sure you say, please withhold news clippings and press releases from the search for responsive records. So you want the agency to scope out any news clippings that are emailed around, right? Agencies like the State Department have a daily clips. They sometimes total in the hundreds and hundreds of pages. If you don't instruct them to take that out of the search, that's going to take up that's going to be the bulk of the records that you get, particularly if you're looking for emails. So building into the request prior to sending it, please omit news clippings and press releases, will narrow the scope of records that are responsive to your request. And reduce fees.
That's definitely a really great tip. And I think some agencies like the State Department sort of do that by default, even, I think, as you request them to include news clippings. Just a quick word on state public records laws. Every state has one. They're very different. The procedures are different. Some of them have administrative appeal options that are very good. Some states have actually state committees or commissions that will adjudicate records disputes without having to file a lawsuit. And those can be really good if you're not a lawyer or if you can't afford to hire a lawyer. And some states don't. And so states can be really powerful because they tend to get fewer requests. And so often you can get things faster. Sometimes you can get records related to the federal government from a state if there are state officials communicating with federal officials, and you can get those records faster from the state than you can the federal. At the same time, sometimes states have worse exemptions, and so you can't get things from them that you would be able to get under the federal FOIA. But I think especially for those of you who may be, in clinics that are working with, state groups or local groups or on state-related issues, don't forget about these various state laws. There are a lot of resources online. The one that I use frequently in my job is the Open Government Guide from the Reporters Committee for Freedom of the Press. But there are a lot of different resources you can have. And so those can be a very powerful resource sometimes to get records as well. And this is a funny one that I pulled from Jason's work at Bloomberg, where he compiled a list of funny responses, but
that was funny.
Yeah. I think this was from the special counsel who was investigating Biden, interviewing a witness. And they gave Jason the interview transcript with everything redacted except someone sneezing.
Somebody has a sense of
makes for great wall art.
yeah. And I think that's it. So anybody has questions?
Any questions? I must also say Jason has a wonderful weekly newsletter, FOIA Files. So if you just Google Jason Leopold FOIA Files, it's a really tremendous, lot of useful information and tips in there. So, and congratulations on your recent case. Do you want to quickly talk about the submarine in the toilet?
Oh yeah.
Who says FOIA is not fun? We have submarines and toilets.
So yeah, very quickly, the back in February 2022, when the news surfaced that the National Archives had retrieved 15 boxes from Mar-a-Lago that Trump of presidential records that Donald Trump took there. I immediately spotted a FOIA opportunity. I filed requests with the National Archives, the FBI, Department of Justice, for essentially a wide range of records that they had on Donald Trump, removing presidential records, tearing up presidential records, and in response to what Maggie Haberman of the New York Times had reported, flushing records down a toilet. so it was a 6-part request. I ended up suing the FBI, excuse me, in July 2022. And, there were 6 different parts, including, any records that, and the FBI was in there, any records that they had about, records being flushed down the toilet. I ended up getting a GLOMAR response, which means, the agency can either confirm or deny. GLOMAR is after, the GLOMAR destroyer that sank, and it was part of the CIA operation. And it's essentially when Los Angeles Times journalists were looking into it, the CIA responded that they can neither confirm nor deny, aspects of what they were looking into. But so the government responded to me with a GLOMAR, particularly on the flushing records down the toilet, and they withheld other parts of my request under B7A. There was an ongoing law enforcement proceeding. And, it's been winding its way through the court for 3 years, and we have challenged their use of the GLOMAR. And just a couple of weeks ago, Chief Judge Beryl Howell, U.S. District Court, she just issued an incredible decision order on, in my case, essentially lifting the GLOMAR as it relates to flushing records down the toilet. She cited the Supreme Court's decision on presidential immunity. I'm not articulating it well because it's in my opinion really worth reading. There were just she turned everything onto back on the government and said, hey, look, because this case is over, meaning the criminal case against Trump, make those records available, and come up with a plan for when you are gonna get those records over to me and anyone else who asks for records. The government responded about a week ago saying, they're still deciding whether to appeal the use of the or the GLOMAR relating to flushing records down the toilet. Every other part of my request where I asked for other things related to the investigation, they'll work on that. But specifically the flushing records down the toilet, they may actually appeal that, which I just think will be a remarkable case if they do. Yeah, so that's the status on that. But it was a really, it was one of those decisions that was just so good.
Oh, congratulations. I read the decision. It's amazing. It's fantastic. So we'll wait and see.
Thanks, Jennifer. Yeah.
Any other questions for any of our panels? Yes, please.
The first one, there was mention about the attorney fees, and if you prevail, your attorney fees would be covered. If you lose, are you on the hook for paying for anything?
No.
That's my first question. The second question is about the privacy exemption. When someone passes away, do those privacy exemptions no longer relate to HIPAA related records or medical records, et cetera?
I was gonna say it not categorically, but a lot of times in practice, yes. I think it really depends on the type of record you're seeking. Sort of the Supreme Court case that addressed this was when Vince Foster, was that his name? Was killed or died, I think died of suicide, and there's a big conspiracy theory. Was it suicide or I don't remember what it was. Anyway, yeah. And there's a big conspiracy theory, and this person who was like convinced that it was like a setup or something tried to FOIA like photos of like the crimes of the scene or like his body or something. And the family asserted a privacy interest, even though he had died. And the Supreme Court said the family does have a privacy interest here. Just because the individual died doesn't mean there's no privacy interest that can be considered. So sometimes agencies will invoke things like a family's interest, but it is often easier to get records related to people who are deceased. I will say for things like HIPAA, agencies will cite things like HIPAA or FERPA or these other statutes all the time. Most of the time, those statutes don't even actually apply, but it's an easy and convenient justification for agencies to use. So for example, HIPAA only applies to healthcare providers. So if an agency is not a healthcare provider under the meaning of that statute, just because it has a record containing someone's medically related information doesn't mean HIPAA justifies withholding it. There might be a separate privacy interest at play under the privacy exemption in FOIA, but that would have to be balanced against the public interest in disclosure. Whereas if it's truly a HIPAA situation, you can't just go to I don't know, the Center for Medicare or Services or whatever and say, I want some patient's file. That would probably be a problem. But if it's like a law enforcement agency and they're not providing healthcare services, they can't just invoke HIPAA, even though they almost always will and try to do that. And same thing with FERPA. Just because you're requesting a record of someone who's a student doesn't mean that the agency can say this is an educational record protected under FERPA. They have to actually fall within the definition of the statute.
To what extent is it possible to submit parallel but separate requests, one narrow, one broad, and have the government, process them separately, or can the government say, no, this is the same request, we're considering this one?
I deal with this a lot, actually, Jason. You probably have tried this too. I mean, this is a common strategy for us because we know there might be a broader request that will take much longer to fulfill, or it's more of a fishing expedition. And we also want a narrow one that might be a good test case and see what exemptions they might try to invoke, or if they just, will produce the records. My experience is that it depends on the agency, how much they're willing to play ball. Sometimes they'll say the narrow one is duplicative of the larger one. They'll close the narrow one and make you wait for the larger one. So what I would suggest to reporters sometimes is for your broader requests, say, I want, all of these records, excluding whatever is in the narrower one, so they can't say they're duplicative. Jason, I don't know if you've had a different experience.
Yeah, I mean, that's essentially the same as I have, which is, each agency is different. But I try to make it very clear that, the broader one is different from, the narrower one, and at least demonstrate that it is.
I have a question for Jason. Have you thought about the possibility that, for some of these requests that relate to Trump and especially records that reflect misconduct, that there's a risk that the president is just going to order destruction of the documents and say pardon anybody who is involved in that, given that he has complete immunity now for his official acts?
I think about it every day.
I
really do.
Yeah.
And the reason I think about that is because I have so many, requests that are outstanding that even date back to Robert Mueller days, in the first Trump administration. Yeah, I'm not quite sure how that would obviously be handled. I mean, I will say that, one of the things that we're going back and forth on is a preservation order, but obviously, as you know, we don't have any evidence yet that they're to present, to a court that there's a risk of this being destroyed, other than, kind of people opining that it could be. But yeah, no, I mean, I think that is definitely, something that is in the front of my mind, particularly going forward, with because I do have, a request out for January 6th records, and obviously with the Mar-a-Lago case. And I know that the Times also has, you know, its own lawsuit as it relates to Jack Smith, special counsel Jack Smith's, volume 2 of his report. So I think all of these records, right, as it relates to Trump are, it's going to be very interesting to see how they respond to it. But I do want to note like one thing that makes me think like, well, maybe they won't. So last week, and I don't know if everyone recalls this, but Attorney General Pam Bondi released all these Jeffrey Epstein documents that were kind of released already previously, but they rolled it out as this big rollout of look what we're doing in the name of transparency. And you know what? I'm not going to take the credit away from them. They, they're being selective, but they did. One part of that record clearly had Donald Trump's name in it of the Epstein records. So it's not as if they like kind of went out of their way to, or maybe they just didn't see it to like redact his name or destroy that part of the record. So, it's still a head scratcher for me.
Yeah, I mean, we have had the conversation too about whether there's anything to be done about it. And I mean, I guess the best thing you can do is put, any attorneys on notice of their obligations, ethical obligations to preserve documents, because
Right.
if they do destroy things and they've done so in violation of their ethical duties as a lawyer, and they could be disbarred, I guess that's not something the president can pardon them for, and they may or may not care about that, but it seems like maybe the only thing you could do.
Yeah, there was a case, I don't know, 20 years ago at this point, or 15 years ago, where the ACLU sued, I think, for like CIA torture files under FOIA, and the government destroyed those in the middle of the litigation.
Right.
And I think the judge ended up awarding like $1 million in fees or something against the government for basically willfully destroying these records. So there are ways, I think, to, there are incentives for agencies to comply, but whether those incentives outweigh the political, equities right now is yet to be seen.
I'd like to ask, and whoever wants to answer, for our requesters, do you have any tips on how to deal with like a cantankerous custodian on the other end of the phone, or somebody really uncooperative? Are there any tips on how best to deal with that short of litigating, where you get the concierge service?
When you say a custodian, you mean like the FOIA officer?
Yeah, I should actually, I'm sorry. Yeah, it could be a PIO, could be whoever's on the other end of the phone that you've been negotiating with, whether it's lifting redactions or do a better search or use my search terms, but you find somebody really uncooperative on the other end. Do you have any tips on how to?
I mean, yeah, if the soft skills don't work, then I guess you have to use your sticks. And I mean, there's not really much you can do if you're not going to litigate. Sometimes there have been cases where orders have said, well, is it okay if I write about this and say that there's a government agency that's withholding documents? And I was like, yeah, I mean, I guess so. It's not going to be front page news. I've never seen a case where it's moved somebody who is intransigent, but that's kind of the only thing I can think of.
Yeah, I have had, definitely have had agencies or FOIA officers who have been uncooperative, but I will tell you that I always try to bring them to a place where, we can at least both of us agree. Like I think that it's like, sometimes it's like, like multi-day effort to get to that point. And, I never like try to use the, hey, I'm going to sue you, but I do let them know that, and I'm in a privileged position where I can just, file a lawsuit, but I'll let them know, like, look, if this is, if we can't agree, I'm going to just eventually have to, take other steps to get these records, which may include, litigating. So, sometimes that can help a bit. It may not be something that lawyers recommend, but I think that I try to essentially come to an agreement with them. Like, what can I do on my end? What are you, how can we get to this place? So I try to keep the conversation going. But yeah, it may not work.
And I would just say for, whether you're a journalist or a lawyer or a law student, I mean, negotiating with sources and that's just part of, or negotiating with other lawyers, that's just part of the job. And right, like whether it's productive to sort of be mean to someone that you're trying to, get to help you. The answer is usually no, it's not. And so I see it as the same sort of like skill set. It's trying to get people who may not have an incentive to help you, nevertheless, at least like respect your position and find some sort of common ground so you don't have to go into litigation. And I know we have like a minute left, but I just want to encourage those of you who are in clinics here, think about how you could use FOIA in your clinical work. I know a number of clinics do file FOIA requests, and some of them come to the Mafia Clinic for advice. But I think, and if you're interested in FOIA in particular, like the Mafia Clinic would be a great clinic to consider, shout out. But it's I think a great way to sort of get practice on civil litigation skills. And it's, to practice negotiating with agencies and
Dave just walked in. I think you have to repeat all of that.
Oh, sorry, Dave. I was just plugging the Mafia Clinic. Yeah, FOIA can be a very, very powerful statute if it's used well. And so I'm sure there are many opportunities for you all who are in school to use it as well.
And do we have any questions from our Zoom audience? No, well then we'll adjourn. Thank you, everyone. Thank you so much, representatives.
Thanks, everyone.
Thank you. Thank you, Jason.